Good morning, and thank you for joining us today, Thursday, December 9th, for our webinar entitled New Employment Laws 2022, presented by Ethos Human Capital Solutions and Merhab Robinson and Clarkson Law Corporation. My name is Denise Ketty, and I am your moderator for this session. A couple of quick housekeeping notes before I introduce today's topic and our expert panel. Our webinar is being recorded and all attendees are in listen-only mode. The webinar will run approximately 90 minutes today in total because we have a lot to cover. The webinar is being recorded and will automatically be emailed to you tomorrow, so don't worry if your schedule does not permit you to stay to the end. Please take a moment now to visit the handouts area on your dashboard. There we go. To download a copy of today's presentation. To access the handouts area, click View on your menu bar and make sure you've checkmarked the handouts and the Q&A area to access the presentation. You can download it from there. If you have any questions during the presentation, please post them to the Q&A area on the dashboard anytime during the presentation. If you would like your question directed to a specific panelist, please add that information when you send in your question. Just a reminder that today's webinar is being recorded and all accompanying materials are protected by copyright. Please note that this webinar is for educational purposes only and should not be construed as legal advice. We recommend that you speak to your professional advisors about the specifics of your business. Again, just a reminder, this information is offered as of today, December 9th. If you are an HR professional and you would like to receive certification of completion for attending this webinar, please type in HRCI into the question box on your dashboard and we will send you the follow-up evaluation and certificate. The certificate will contain the program approval number needed to enter into the HRCI platform. As I mentioned today, our topic is new employment laws for 2022. Let me introduce you to our panel. Our legal expert today is Curtis Urian, associate at the law firm Merhab Robinson and Clarkson Law Corporation. Curtis is in the firm's transactional department where he advises clients in real estate, finance, business succession planning, corporate and employment law. In addition to his work at the firm, Curtis contributes articles to law journals and is a part-time lecturer in the Business and Political Science Department of the American Jewish University in Los Angeles. He has also been recognized by superlawyers.com as a rising star in Southern California for multiple years, and we're happy he's able to join us today. Our human capital person is Linda Duffy, President and founder of Ethos Human Capital Solutions. Linda has over 30 years of executive human capital experience and is known as the people problem solver. Linda and her team at Ethos are known for building the magic of human connection with their unique approach to HR consulting, recruiting, training, and payroll support programs. The Ethos team works with your company by developing strategies for business leaders to get the right systems, people, and culture in place within your organization so you, as a business owner, can focus on running your business and achieving your goals. Linda, can you kick it off for us today?
I can. Thank you so much, Denise. Welcome, everybody. Happy to have you here with us today. We're going to have a large crowd, and as Denise said, it probably will go closer to 90 minutes. We want to take enough time at the end for questions. Just a reminder, if you just jumped on and you want HR continuing education credits, just put HRCI into the question section and we'll make sure to send you the link so you can take the survey and get to the certificate afterwards. Here's today's agenda. We've tried to group all of the new case law and all of the new bills that were passed last year into these categories to make it a little bit more clear so we weren't just jumping around. So we're going to review a few things having to do with COVID and safety overall, talk about wages because there's been a lot of bills having to do with different things in wage and hour laws, a couple of record keeping items to note, a change with regard to California Family Rights Act. There's a few things having to do with independent contractors because that's our life in California now. And then some really important information about severance agreements and arbitration agreements. And then there's a few random, very specific, industry-specific rules that we're going to talk about. We've gotten good feedback on the format we used at the last couple of webinars, so we're going to keep this very conversational and not just present. So I hope that works for everybody today. And as Denise told you, as you have questions, just drop them into the question section and then we'll get to those at the end. Okay. So Curtis, let's start talking about mandatory vaccines because that seems like a conversation I know we have with our clients all of the time. Um, there is no national or statewide, like everyone must get vaccinated, right? We were talking the other day about how Biden withdrew one of his orders and another one got challenged in the court system. So right now it's really looking at different industries and maybe some local mandates, right?
Right, yeah, we're just looking at statewide mandates. And even then, we don't have any fully statewide mandates. We just have certain regulations and mandates from the California Department of Health that apply to specific industries. And so those would be California state employees, healthcare workers, public school teachers, congregate settings, and workers in senior care facilities.
Yeah, and the local mandates for the most part are really, if you go into like the city of Los Angeles, like my cousin did recently, he went into a restaurant or bar, you have to show, vaccine status as you're going into like bars and restaurants, gyms, things like that. I have season tickets to the Ducks, so I know when I go into Honda Center for a game, I have to show my ID and I have to show my vaccination card before I go in, or I have to have a test, a rapid test right on the spot. So certain areas are going to have those requirements. But there's nothing that says like, hey, every single person in this state or in the country has to be vaccinated. Now, you are allowed to have a mandatory vaccine policy, right? And if the company mandates vaccines and the company has to pay for the time it takes to get the vaccine and pay for the vaccine if there's a cost associated with that. Just remember, if you want to go that route, that there are some exceptions to mandatory vaccines and people are allowed to sort of apply for an exemption. And what would those reasons be, Curtis?
Yeah, so we spoke about this somewhat last month. If an employee has a qualified medical reason, some kind of medical condition that prevents the employee from receiving the vaccine, then the employee can request an accommodation to be exempt from the vaccine requirement, just like any other medical accommodation request. And also, the employee can request an exemption for sincerely held religious beliefs. And when an employee does that, whether it's a medical condition or it's a request for an exemption for sincerely held religious belief, the employer is obligated to engage in that timely, good faith, interactive process to determine whether the requested accommodations are reasonable or whether they impose an undue hardship. And if they are reasonable, identify what those accommodations are, whether it's work from home, whether it's segregating at work, keeping distancing, environmental controls. Those are just some examples of reasonable accommodations that an employer would have to evaluate.
And if somebody on here wasn't on our webinar last month, feel free to go out to our YouTube channel because we upload the recordings of our webinars, Webinar Gods Complying, and we have them out there. So you can go to youtube.com/Ethos HCS and you'll find all of our past webinars there. And if you didn't see the one on interactive process, you can get more information from watching that online. You might also just want to subscribe to that YouTube channel because then as we do upload new videos, mostly webinars, you'll be notified of it. The other thing to know about this, I just like to point out is people should consider the ramifications of having a mandatory vaccine policy. I'm all for vaccines. I've had my booster, I'm all in, but you have to also think in this culture right now, it's really hard to hire people in general. So if you're going to limit your potential candidate pool, just be smart about that and make sure that that's a consequence you're willing to take, and just your cultural implications of that and how the rest of your workforce is going to feel either way, right? If you're not requiring vaccines or if you do. Similar to the mandatory vaccines, we ran across this last week with a client that did not know that their employees that were not vaccinated should be wearing masks in the workplace. So the California Department of Public Health does have a requirement that face coverings be worn in certain indoor settings, regardless of vaccination status. And there's a list there, right? Very similar to where the vaccines are mandated, right? Public transit, schools, emergency shelters, healthcare, things like that, right? Anyone that's been to the doctor in the last year knows you walk in, you put on a mask. But masks in the workplace are required during outbreaks for everybody, but otherwise just required indoors if you are not vaccinated, right? So you want to make sure that you are following this mask mandate, and it does require that you have some sort of record of your employee's vaccination status. Curtis, what are you recommending to your clients? We've been recommending an attestation form.
Yeah, I like the attestation form. I think this is my personal opinion, I think it's too much of a burden to get a copy of the vaccination card, even though that is an acceptable option. I think the easiest thing to do is get an attestation form from the employees, have them state in writing when they got the shots, when they were fully vaccinated, what type of vaccine did they receive. And just to further iterate on this, the order for the public health department is industry specific. So we had the list of industries that were required to wear masks indoors regardless of vaccination status. But if you're not in one of those industries, meaning all other employers, regardless of the industry, are still subject to the Cal OSHA emergency standards, which does require masks indoors for employees who are not fully vaccinated. And it also requires employers to provide an N95 respirator upon request. And that's all employers, it's not industry specific.
Yes, and one other thing to remember about the attestation form, we should just mention this. If an employee refuses to sign an attestation form or complete it or doesn't want to share their vaccination status, I don't know if there's anything we can do to require that, Curtis, but the rule is that you must treat them as though they're unvaccinated. So they would be required to wear a mask in the workplace.
That is correct.
So let's talk about COVID notifications. AB 654 was a cleanup bill that actually went into effect a couple of months ago. And it just tried to make some of the language regarding COVID notices, the notifications you have to give employees when there's exposure, things like that, a little bit more consistent. And so this one just changed the outbreak language to say that if there is an outbreak, then you're required to notify your local Department of Health 48 hours or 1 business day, whichever is later. I think, Curtis, before it just said 1 business day. Is that your understanding?
Yeah, that was my understanding. It was just 1 business day before.
So now it's 48 hours or 1 business day, whichever is later. So it gives us, I guess, a little bit more time. I don't know. I'm trying to think of an example of the day where that would make a difference, and probably has to do with the weekend or holidays. But anyway, there is a list of employers that are exempt from reporting outbreaks, and those are healthcare facilities. It added adult day health centers, community clinics, community care facilities, and child care facilities. I'm not sure why they don't have to report outbreaks, because you would think that we would want to know that, but that is what the rule is. So in terms of action items, and we're going to try to share this with you as we go through these, just to give you a reminder of what actions we think you should be taking as a result of the change in the law. Just a reminder on this one, every employer in California is required to have a written COVID prevention plan. We have written a ton of these over the last year and a half. And so if you need help with that, please reach out to us, but it's required of all employers. So you want to keep that updated as the laws change. You also have a requirement to train all of your employees in different COVID procedures like cleaning and disinfecting and things like that. So make sure that you have that in writing. There's no minimum number of employees for that one. And then also just update your notification process and any associated paperwork to have the new language of 48 hours or 1 business day.
Yeah, that's correct. And just to emphasize that the Cal OSHA emergency standards still are in effect, and that's where we're condensed the slides for brevity to go as fast as we can here because we have a lot to cover. But just to emphasize that Cal OSHA emergency standards has been revised several times, but it's still in effect, and that's where we're getting most of these requirements from.
That's great. Do you want to start on this one, Curtis? SB 93. This is a pretty big one if you are in one of these industries.
Yeah, so California, the legislature is trying to help out those who are affected by those employees in the hospitality sector who are affected by COVID layoffs. So SB 93 requires makes an affirmative requirement that employers who are in the hospitality section industry, so these are hotels, private clubs, event centers, airport operations, event caterers, et cetera, any employer in that sector. And event centers is defined very broadly, and it's any employer that may be connected to an event center. So this could potentially include restaurants. If a restaurant is preparing meals, preparing food for an event, then that restaurant would be subject to this new law, which says that until the end of 2024, employers must offer COVID-related laid-off employees specific info about jobs that become available and offer positions to laid-off employees based on a preference system. The specific definitions of employees and what laid-off means. If you have any specific questions on that, please read the bill. Please contact us. We're happy to go through that with you.
Yeah, this is a pretty serious thing. I mean, they go through and they have definitions for all of this, like we put the definition of laid off employees here, but there is a lot of devil in the details on this one. So please just Google SB 93 if you are in one of these industries and just read the details, because there are very specific notification requirements. And there's also a notification if you decide to hire somebody instead of a laid off worker. So let's say you laid off Joe and then you decide to hire Susie Q instead, then there's another specific notice you have to give Joe to say, hey, we hired Susie Q instead. So there's a very detailed process and way too much that we have time to go through here. And I don't know how many people on the phone are in these sections, but just please go read that bill. This one, to me, Curtis, is a money grab. I don't know if you think of it the same way, but
it is. I mean, you know, I'm not a fan of the legislature, and this is another example that shows why I'm not a fan of the legislature. SB 606 expands Cal OSHA's enforcement authority, and it creates a rebuttable presumption that a violation could be committed by an employer that's company-wide at multiple work sites. It's enterprise-wide if the employer has written policies or procedures that violate certain safety rules. So you don't even have to have had an accident. You don't even have to have had an injury. You can be presumed in violation of the law if your policies and procedures have mistakes, or if there's evidence of a pattern or practice of the same violation committed multiple times, then the Cal OSHA will have a presumption that the business, the company as a whole, is in violation of the law just because they had a couple incidents at one or two locations.
Right. So if you have written policies or procedures that go across multiple locations, this applies for you. It also adds a definition of egregious violation, and a violation could be egregious if they feel the employer made no reasonable effort to cure the violations, or there's worker fatalities or a large number of injuries, if there's persistent injuries, if they have an extensive history of prior convictions, or if they just feel that there was an intentional disregard of the health and safety responsibilities, because could that be any more vague, or a large number of violations were committed by the employer. So that has additional penalties to it on top. So on this one, just make sure that you're constantly being vigilant about your policy and procedures if they're safety related, that you're taking safety seriously, and especially if you have multiple work sites, just be careful about how you're documenting everything across those. You just want to also keep really good notes was one of the recommendations I read that I thought was smart about when you're implementing and when you're changing any sort of policies. So you might want to keep revisions, things like that, and just keep detailed notes on those. Anything else on COVID or safety, Curtis? Are you ready to move into my personal favorite, wage and hour stuff?
I'm ready to move on from COVID. There's no question about that.
Okay, so here's another money grab, but AB AB 1003 has to do with wage theft. And this has basically created a new category that says, hey, if an employer steals wages, right, has theft of wages that includes gratuities of over $950 for one employee or $2,350 for more than one in a 12-month period, it is considered grand theft under the law. I think the weird part about this law, besides just that, is that independent contractors are included in the meaning of employee. So presumably if you don't pay your contractor or you don't pay the whole amount or something like that, it could be considered grand theft. And what happens if that happens, Curtis?
So if that happens, you could be charged. And when I say you, I mean the employer could be charged with misdemeanor or felony, and the prosecutor could potentially seek fines or imprisonment. Now, a couple things I want to emphasize here is 6 or 7 years ago, the law was changed so that the payment of wages or the failure to pay wages creates personal liability. So you may be thinking, oh, these are just fines and felonies that the corporation could be charged with, but no. Any person in the chain of command is responsible for paying wages is personally liable for the failure to pay wages. So this new law ostensibly extends to individuals as well. So the state could start charging individuals with felonies for failure to pay wages. Another point I want to make is that the law defines the word intentional very broadly. So typically when you hear the word intentional, you think, well, that means I actually had to have thought about it, I had to want it, I had to desire it, I had to wish to not pay wages. But that's not how the law defines the word intentional. That's not how the California Labor Code defines the word intentional. It's very broad. Almost any instance where wages are not paid will be deemed intentional. So this is a very strict, very harsh law.
Because Curtis,
we want to emphasize. Oh, sorry. Go ahead.
No, I was asking you a question. You finish your thought.
Yeah. So we just want to emphasize how important it is to make sure that wages are paid accurately and timely in California. California has very strict, very harsh consequences for the failure to pay wages.
So that could potentially include things like you've misclassified a worker as exempt, right, and didn't pay overtime, or, especially with the minimum wage increase that we're going to talk about in a second, but meal and rest period penalties and practices there, timekeeping policies. You don't have, again, if you're not paying overtime, right, that's would come into effect if it hit those numbers.
Yeah, wages is defined very broadly as well.
Yeah, and I think the theft
it doesn't include, it includes more than just time or money for all hours worked. It includes a lot of these ancillary payments and penalties and premiums that employees are owed.
Right. The theft of wages, the way it was defined in here is the intentional deprivation of wages, and that's defined in Labor Code Section 200. Gratuities as defined in Labor Code Section 350. Benefits, other compensation. It says by unlawful means with the knowledge that the wages, gratuities, benefits, or other compensation is due to the employee under the law. So as Curtis said, super important that your managers, your HR people, your payroll people are familiar with wage and hour laws. Curtis, this one is all yours.
Right. So another consequence for failing to pay wages is that the labor commissioner can file a lien against real property owned by the defendant. And again, like I said before, there's personal liability for wages. So individuals who work at a company and owners and officers are potentially personally liable for the non-payment of wages. And the labor commissioner can now file a lien against the real property owned by those individual defendants, and they can file a lien before the case has even been decided or before a ruling has even been made.
That's sort of scary.
Very scary. Yeah.
Yeah. So to put this in practical terms, um, if if a business owner fails to, you know, pay something, right, then their home, like if they own a home, it could be, they could have a lien put on it.
Sure, your home could be at risk.
So it's not just like I own a commercial building, it could be your personal property.
Correct. It's very scary.
Yes. The next one, not as scary and probably doesn't apply to a lot of people. And there's been this long-standing, I don't know, ability under the law to pay people who are mentally or physically disabled less than minimum wage. So the way I think of this is like Goodwill, for example. They have a workforce. They have a lot of people there that have some sort of mental or physical disability. They would not be required to pay them minimum wage. This bill sort of phases that out. So if you do have employees and you did apply for a license so you could pay them under the regular minimum wage, just know you can continue to renew your license until January 1st, 2025, but they're not going to issue any more licenses. State of California really wants to treat all employees equal under the law, so they're not going to, we'll say, discriminate against anyone that has a mental or physical disability. The next slide isn't so much a specific bill or case law, but just a reminder. I told Curtis that one of the things that we've been seeing come up a lot is that during the pandemic, people have moved out of state or moved states or gone someplace else, right? And a lot of times I think employees forget that they should mention that to their employer, right? So it's causing some issues for some of our clients when they want to bring people back into the office, or even if they're okay with remote work, but an employee will have moved out of state, because some of the potential impacts are things like this. Payroll taxes need to be reported wherever the employee is living and working. So if you had an employee here in California and now they moved to Minnesota, you know, Minnesota, I think in particular, has like you have 30 days until you have to file in Minnesota and start reporting payroll taxes there. So the reason that that's important is because it can affect some other benefits. So for example, we've had people who move out of state and then they go and file for unemployment, and you know, Texas says, hey, we don't know who you are, because no payroll taxes have been reported in the state of Texas. And so that will screw up that person's claim for unemployment benefits, and it takes a while to unravel those. The other thing, though, it could affect different benefits. So for example, in California, we have a mandatory disability tax, right, that employees pay, and then they can apply for SDI benefits if they need them later on. Well, Arizona, for example, an employee has to affirmatively opt into that tax. So if somebody is in California, maybe they have it come out of their tax, they go to, or out of their paycheck, they go to Arizona and they may not realize that they have to opt in, and then they go to apply for SDI and they realize there's no payment to be made to them because they haven't paid into that system. Leave of absence laws are changed, right? Depending on what state. So in California, maybe they're entitled to a leave of absence, but now they work remotely. They're not within 75-mile radius of so many employees, and all of a sudden they don't have that benefit. And then overtime rules are definitely changing as well. So all of that, just to keep a reminder. The other thing is, if you have employees that are in other states that move into California, remember, for overtime purposes, their minimum salary is going to be a lot higher in California. So I was just reading about a case where an employee was living in Florida, they relocated to California, they were at like 52,000 and salaried exempt in Florida. They came to California and then they sued their employer because they were unpaid for overtime basically all that time and should have been considered non-exempt. Curtis, anything you want to add on this one?
Yeah, just when you're looking into these issues, be sure to consult with your CPA too for the proper reporting of the payroll taxes and disability taxes and so forth.
Yeah, definitely important. All right, here's my favorite topic of the day, regular rate of pay. So this isn't meant to be a math quiz for anybody, but this is something that we see where there's problems over and over and over again. We're working with a client right now, for example, that you know, they're paying their employees a base rate, but they were giving them they were giving them a bonus on top of that, but they were not calculating the regular rate of pay in order to pay them overtime and sick. So what I mean by that is I just want to refresh everybody's recollection that non-exempt employees, so think hourly for the most part, but non-exempt employees who get some sort of bonus, commission, shift differential, other types of pay on top of their base rate, you have to factor in that extra bonus amount when you calculate their overtime. And so the overtime in this example on the right is you say, okay, their base rate, we're paying them $20 an hour and they work 44 hours. The overtime rate is not 1.5 times 20 because they received a production bonus. So it would actually be $31.70. And if you do not understand how that calculation is done, or you're not aware that you need to be factoring in certain types of bonuses, please, please, please call us. This is a huge liability, Curtis. You want to explain that?
Yeah, we see this all the time. I'm working on a case right now that I'm trying to settle where there was a mistake on calculating the regular rate of pay for paying overtime, and it turned into a huge problem. Another attorney in my firm just handled the matter where there was a production bonus that was paid and overtime wasn't calculated properly. The regular rate of pay can be complex. It can be complex. So if you're ever in doubt, if you ever have any questions, call us. We can walk you through it. But what most people fail to realize is the regular rate of pay is supposed to be used in many different contexts. And
yeah, so overtime and sick.
We're going to talk about those in a couple more slides too. But just be aware that the regular rate of pay is not the same as the base rate of pay. And it's calculated by adding up the total compensation in a week and divided by the total number of hours worked.
Right, and there's a different calculation if it is a flat sum bonus, like our client that we're talking to next week. The flat sum bonus is not tied to the number of hours being worked, but they were getting a $25 bonus for every 5-star review they got for the work that they had performed. So that is a different calculation. So this is complex. And if you don't understand the differences, like Curtis said, please reach out to us. The other thing is this liability can potentially go back 4 years, right, Curtis?
That is correct.
So there is a new case, and one of the reasons we wanted to point that out is because there is a new case that came out a few months ago, Pharah versus Lowe's Hollywood Hotels. And this basically said, add to the list of things that need to be paid at the regular rate, the meal and rest period premium pay. So if you have an employee who is not relieved of all duties, or if they have, missed a meal period, didn't start it by the end of their 5th hour, things like that, that meal period penalty now has to be paid at the regular rate of pay. And I believe they also said that this law was retroactive, which never makes sense to me.
Yes, it is retroactive. I was surprised by this case, but I wasn't at the same time. The meal and rest period premium is essentially a penalty. It's wages, but it's not wages. So a penalty shouldn't be, in my opinion, a penalty shouldn't be paid at the regular rate. But the issue was with the labor code. Again, like I said, I'm not a fan of the legislature. The labor code was not drafted particularly well. It said that the premiums were to be paid at the regular rate of compensation. And so there's a question of what does that mean? Does regular rate of compensation mean the same thing as regular rate of pay? So I don't know. So I get why the court had to make that distinction and state that regular rate of compensation means the same thing as regular rate of pay. So I don't like the case, but the decision does make sense. The main takeaway here is regular rate of pay for meal and rest premiums.
So just review all of your wage and hour practices, because as we said a couple of slides ago, now there's also this new, wage theft penalty on top of it. So you just want to be really careful. Some of the more basic wage and hour things is we always like to point out that the minimum wage is increasing. So if your company has 25 or fewer employees, then you're going to be at $14 an hour starting January 1st. If you have 26 or more, you're going to be at $15 an hour. And then finally, a year from now, everybody will be on the same minimum wage. There also keep in mind local minimum wage ordinances. So all of these cities are the ones that I could identify pretty easily that have something local. So if you have employees in these areas, you need to make sure that you're complying with the local minimum wage as well. So always check that to make sure. Some of these cities have minimum wage differences depending on their size as well. So just check if you have anybody working in those areas. And again, keep in mind, if you have remote workers, they may be, you may be located in an area not affected by that, but if they live in an area and they're working from home now, you're gonna have to pay them at that local minimum wage. There's also a couple of special minimum wages that come up every year, computer professionals and also licensed physicians and surgeons. So computer professionals are going from $47.48 up to $50. And currently doctors are at $86.49 and they're going to $90.07. And that is the minimum wage if you want them to be exempt under the law. But I also want to remind everybody to make sure that you're checking the duties test. It's not just about how much you pay them, they also have to qualify. And Curtis, I don't know about you, but we see a lot of issues around the computer professionals. Do you want to talk about that at all?
Yeah, so a computer professional has a very specific definition. It's not just somebody who works with computers. It's not just your IT person. A computer professional is really somebody more like a software engineer, somebody who's creating your software, somebody who is at a high level of skill and expertise. There are other ways to possibly classify an IT or computer employee as exempt under either the professional or the administrative exemption. But just know that the computer professional exemption has a very high standard for the types of employees that qualify for this exemption.
And also, when the minimum wage goes up, remember that the minimum exempt salary goes up, and the minimum exempt salary is twice the state's minimum wage. So you would take whatever, your minimum wage is, multiplied by 2, and then multiply by 2080, which is the number of hours in a year, and that's how we come up with the minimum exempt salary. So a lot of times people ask, well, if the minimum salary or minimum wage in the city is such and such, then do I have to multiply it by, 2080 and 2? The answer is no, it goes by the state's minimum wage. So again, if you have between 1 and 25 employees, in another month, that minimum salary is going to be $58,240. If you have more than 26 or more employees, then it's going to be $62,400. So you just want to make sure, because this is super easy to audit, right? Like we do audits all the time. We'll go in, we'll say, run us the census of your employees that show us how much they're making and their FLSA status. And next thing you know, we're like, oh, all of these people are under this minimum. So that's something to keep in mind as you take a look at the new year. So action items, Curtis, there's a few of them for wage and hour stuff.
Yeah, you just need to evaluate all of your employees' wages and their salaries to make sure that they meet the minimum requirements, especially your exempt employees, to make sure that their salaries meet the new minimum threshold to be exempt.
Yeah, and the last bullet is just a reminder that this does cause issues every year when the minimum wage goes up, because you hired somebody a year ago at minimum wage, you're going to bump them up, but now the next person you hire, the employee from a year ago is now training, right? They're training their coworker who's making the same amount of money, and it's not going to feel fair to that employee. So take a look at that as well, because as you bump up people and have a new higher minimum wage, you probably are going to have to do something to address the people that have been there that are now going to be at that same level of pay. Curtis Donahue, this case is sort of funny to me because I find it odd that an employer would have chosen to round meal periods, but why don't you tell us about this?
Yeah, this case didn't surprise me. And I didn't think it was a bad case either. Like you, I was surprised that employers were taking their employees' meal breaks, so they worked less than 30 minutes, say they worked 27 minutes, and then they would round that meal break up to 30. There is some authority in federal law, and there is some California case law, which is the Seas Candies case, that says that employers can round time punches at the beginning and end of shifts. So maybe some employers took liberty with those laws and tried to apply it to meal break periods. But yeah, the court said no.
Right.
Must take at least a full 30 minutes, which kind of makes sense to me. I really don't take issue with this case.
Yeah, nor did I. And it's just a reminder because we recommend to our clients don't round even beginning and ending because it's so hard to prove that it was not to the detriment of the employees, right? So we just say, hey, just don't round at all, make it easy. But we do have some clients that choose to round.
Yeah, and there's a lot of people who take this case and think that it means that California is slowly, the courts are slowly going in the direction of getting rid of rounding practices. That may be true. That may not be true. I don't know. Because the California law, at least from a statutory standpoint, is somewhat ambiguous for rounding practices. So there definitely is risk involved when rounding time punches, either at the end or beginning of the shift.
But definitely don't do it for meal periods. What about this case, General Atomics versus Superior Court?
Yeah, I like this case. This is a win for employers. So as we mentioned before, the regular rate of pay is complicated to calculate. And not just calculating it, the employer is also required to list on the wage statement the different hours worked and what the different rates were inapplicable for those different hours worked. So if you have an employee who's working shift differential, getting a flat sum bonus, receiving production bonuses, they're going to have a complicated wage statement. And General Atomics basically had that situation, complicated wage statements. And the plaintiffs in this case took issue with how the wage statements were being written and provided to employees. But there weren't actual issues with the calculation. So employees are still being paid correctly, but the wage statements were somewhat confusing. And so the court said because the employees were being paid the same rate, they didn't actually suffer any damages. There weren't any losses. So just because the employees didn't understand the calculation on the wage statement doesn't mean that there was any penalties or any damages. So the court actually found in favor of the employer, which is good.
Hallelujah.
And the takeaway here is that get the calculation right and try to put it on the wage statement as best as you can. But as long as you're paying the employees correctly, you should be compliant with respect to your wage statements.
And that is great news. Substance over form won out for once. Okay, and talk about Morales versus Factor Surfaces.
Okay, so this was a loss. And, you know, this comes up a lot for me when working with clients. Employees sued for lost wages or unpaid wages, and the employer didn't have time records. The employer tried to say that the employee kept the time records in the company truck was broken into, and the records were stolen or destroyed as an excuse as to why the employer did not have the employee's time records as a defense to paying the alleged lost wages. The employer lost. The law has an affirmative requirement that employers keep records of all time worked. It's not the employee's job to keep those records. So when the employer in this case tried to come up with defenses, the court basically said, we don't care. It's your job to keep the records. You didn't, so we're going to believe what the employee reported and what the employee was able to prove and demonstrate. So the takeaway here, again, you got to keep those time records. It's the employer's job to keep it.
Yeah, and there's nothing in the law that says how you have to keep the time records. I always tell clients you could write it on a napkin if you want to, but you're going to have to be able to produce them later or you're going to lose in court, right? Because that employee's been keeping meticulous records, right, of when he's been working, and so you're going to be at a loss there. So
Yeah,
that's
working on a matter right now that's not going to turn out well because the employer did not keep those time records.
bummer. So that's it for the wage and hour. Let's talk about record keeping. There's just a couple of things here. This this law seemed like on the surface was going to be a win from employers, and yet it really doesn't change a whole bunch. So everybody knows hopefully that you have a requirement to post certain California required posters and certain federal posters in your workplace, right? The legislature said, well, wait a second. So many of our workers are now working from home remotely. So how are we going to get them those posters? And so it gives you the ability to email the required posters, but just the California required posters, because the feds haven't given you that same right. And also it says that you still have a requirement. The employee is supposed to literally print these out at home and put them up someplace. So good luck with that, because I can't imagine that happening anytime soon. But you can give people electronic posters, at least for the California ones. If you do have a physical location, an office location, then you still are required to post them there as well. So what we recommend to our clients is, just take all of the posters, download them, put them in a file someplace, send the people a link, and just get some sort of confirmation that they know that that's where the posters are, that they can access them there. Curtis, do you have any other advice on that one?
I don't. The law, the way this bill was written is vague. It's the actual bill is only like 2 sentences long, but again, it's vague. I mean, I like the idea that we know that we finally have the right to send the posters electronically, but then it's written vaguely about what happens after that. So it's a win, but it's not. So, but I agree. The takeaway is send your posters electronically and get confirmation that employees receive them and understand them.
Perfect. This one, Curtis, why don't you explain this one on record retention?
Yeah, so prior to SB 807, employers are only required to keep 3 years worth of records. That's personnel file and payroll records. The issue with that is that the statute of limitations for wage and hour claims and now statute of limitations for sexual harassment, discrimination, retaliation claims is now 3 years. But in California, we have Business and Professions Code 17200, which is the unfair business practices law, which is alleged extends the statute of limitations for an additional year. So effectively, somebody can sue for wage and hour claims for 4 years worth of wages, but the employer is only affirmatively required to maintain those records for 3 years. So I think that this law makes sense in that it's extending that record retention requirement to 4 years. It's basically recognizing that there's a gap in the law. So I'm okay with this requirement. But even still, before this law, we generally recommended to our clients that they keep records up to 7 years. That's the statute of limitations for the IRS. And so if you keep your records for 7 years, you're going to be safe with regard to any kind of state claim.
And I'm going to make one exception to that, which is Form I-9s. I tell everybody, shred those as quickly as you can, because I see so many mistakes on them, and it's like $100, $100, $100. It's like each one of those I-9 forms can be fined up to like $2,100. So just know on your record retention, have a shorter record retention for your Form I-9s. If you don't know what that rule is, reach out to one of us and we can help you with that. But just go ahead and update your record retention policies and practice accordingly. And again, we would recommend just 7 years. All right, California Family Rights Act. There is one change on this. It was cleanup legislation because somebody forgot to include parent-in-law in the definition of family member. So all of you hopefully know CFRA has changed significantly over the last year, because earlier this year it dropped down to 5 or more employees in terms of eligibility. or companies that are covered, I should say. So eligible employees can take leave to care for family members that have a serious health condition and someone forgot to leave parent-in-law. So make sure you go back into your handbooks and you change the definition of the family member to include parent-in-law as well. And then Curtis, there was a second part of this bill having to do with the mediation program that I'm guessing some of the people on this call don't know anything about.
Yes. So it is a violation to, if an employee makes a request for time off under CFRA and that time off is denied, but it probably should have been approved. There's different violations and there's a procedure for an employee to sue. What this law does is it creates a kind of a model test program. It's a small employer mediation program for employees of small employers to engage in mandatory mediation with the DFEH to try and resolve these issues for requests for leave under CFRA without having to go to litigation. It should be an opportunity to save costs of litigation and save time.
Right. And part of the cleanup on this was just the details, because somebody realized, the employee could go to the DFEH, file their complaint online, close it out, get a right to sue letter, but the employer doesn't get a copy of that right to sue letter. So you don't even know that that's what happened, right? So this actually requires the DFEH to tell employees, hey, you need to go to this mediation program before you can just go file a lawsuit. So if you have between 5 and 19 employees, you're covered by this. So that's the good news on this one. Independent contractors. This never goes away, does it, Curtis? So
it doesn't.
And it's interesting,
all the time.
The new laws that are popping up, you can tell who's got a strong lobby in California because it's sort of random. So we're going to talk about some types of workers that could potentially, maybe, considered independent contractors. But I always like to include this slide first to say, don't get too excited, because this is actually on EDD's website, right? So it's a big note. After January 1st, 2020, workers will be considered employees unless proven otherwise, meaning you don't get the benefit of the doubt, employer, right? The worker's going to get the benefit of the doubt. So just keep that in mind. So the ABC test, people remember from AB5 a few years ago, the burden is really on the employer to prove the worker is not an employee and can be an independent contractor. And there was this ABC test that said, it has to meet all three of these, right? Not just one, but all three, that the worker's free from control and direction, right? The worker's performing work outside the usual course of the business of the hiring company, which is usually the one that hangs people up, and C, the worker is customarily engaged in an independently established trade, occupation, or business, meaning they're offering these services to other people, right? Anytime we talk to one of our clients and they're saying, oh, that person's an independent contractor, and I say, well, how often do they work for you? They go, oh, 40 hours a week. I'm like, yeah, that's not going to go well. So the thing to know is that even if, Curtis, people can get a worker through on this, that doesn't leave them free and clear, because there's still this Barolo test.
Right. So the Barolo test was Barolo was a California Supreme Court holding from many years ago that established the test for classifying whether a person is an independent contractor or employee. The Barolo test is still in effect. So what does that mean? If if a worker passes the ABC test, meaning according to the Dynamics holding in AB5, if a worker passes the ABC test, they must still then go on and be subject to the Barolo test, which is a set of 11 factors that either weigh in favor of an independent contractor or weigh in favor of an employee. California is making it very difficult to classify a worker as an independent contractor. There's essentially two tests that must be passed.
And I think
that becomes
sometimes
important.
People forget.
Right. And that becomes important because AB5 has a long list of exceptions.
So let's look at some
AB5,
of those.
it was, I think this is the second or third time that AB5 is being amended to add more exemptions and exceptions. So just because somebody falls into one of these exemptions, and we're just having some of the new ones here, just because somebody falls into one of the exemptions doesn't mean that you can skip the Barolo test. So if you have a worker that meets one of the exemptions, you must then still go on and perform an analysis under Barolo.
So
So
AB
these are some of the new.
2257 was from last year, I think, Curtis. So this first one, I think, was last year that expanded certain exemptions. Was sometime during the year that this happened. It's not new for January 1st. So there were categories of musicians, artists, music industry, there was home inspectors, and then very randomly manufactured housing salespersons. Very random to me. Landscape architects, underwriters, digital content aggregators, that one was modified a little bit, and freelance translators, right? So as Curtis said, that doesn't mean you're off the hook entirely. You still have to take a look at it from the Barolo standpoint. These are the two new ones though, Curtis. You want to talk about these?
Yeah, and these are exemptions that are limited in time, so they will only be in effect until December 31st of 2024, so the next 3 years. And these are for newspaper carriers, licensed manicurists, construction, trucking industry contractors and subcontractors. Also add insurance claim adjusters and third-party administrators.
So if you play in those spaces, you can look up AB 1506 and AB 1561, and I'll talk a little bit more about that. I don't think there's probably a lot of people on this call that are in these areas. So we're going to move on to case law, Vasquez.
Yeah, so Vasquez came down earlier in the year, but we just wanted to repeat it and emphasize that AB5 is retroactive, meaning if a worker was classified as an independent contractor in 2019 and is still working for a company, just because the person was classified prior to 2020 when AB5 went into effect, the law is retroactive. So you have to go back and evaluate any prior or any existing independent contractors and determine whether they comply with AB5 and Barolo.
So one of the action items we would have is, review all of your independent contractors just to make sure that they are meeting the criteria for independent contractor status, because again, we're going to tell our clients just don't even try to have an independent contractor for the most part. Especially I've been through audits before with some of our clients where the state, whether it's EDD or whomever, the last one I went on was with EDD, they're looking to see, are you paying, the first thing they look at, in fact, was, are you paying them under a social security number or under an EIN, right? They want to make sure that this person has an independent business. So if you're paying paying workers as independent contractors under a social, I would make that a high priority to fix that. Curtis, severance agreements. This is another sort of big one.
We haven't had to make any major changes to our form settlement or severance agreements in a while, but because of SB 331, we're going to have to. So beginning in 2022, we're going to have new severance agreements and new settlement agreements. So current law prohibits settlement agreements from having certain confidentiality terms. Meaning current law in California says that a settlement agreement or a severance agreement cannot have a restriction on disclosing instances of sexual assault, sexual harassment, discrimination, other acts based on sex. If an employer violates that law, the penalty is that employer loses the ability to deduct the payments made, deduct the payments made from their taxes. So there was a question there for a while, and well, we can still do it, but we'll just lose that tax benefit. But SB 331 is expanding the prohibition to include acts of workplace harassment, discrimination not based on sex. And it is also prohibiting an employer from requiring an employee to sign a non-disparagement agreement or other document that would deny the employee the right to disclose these acts. And so there are some elements of the new law that are still kind of good for employers. Employees can still prohibit their employees from disclosing protected trade secrets or confidential or proprietary information, the amount paid under a settlement or severance agreement can still be confidential, but you just can't have any kind of settlement or severance agreement that prohibits the employee from disclosing any of these bad acts that took place in the workplace. And another big change is that severance agreements, when presented to an employee, must be held active or must be held open for 5 business days. An employee can waive those 5 days and sign earlier if the employee makes a knowing and voluntary execution of the agreement, and as long as the terms of the agreement is not changed. But again, there used to be that we could hand out a severance agreement to anybody under 40 and have them sign the same day. But now that's changed. Now we have to provide them at least 5 business days. So that's a big change we'll be working on. We'll be preparing these settlement agreements and new severance agreements for 2022.
We'll look forward to that, Curtis.
Yeah.
Okay, arbitration agreements had a lot of activity over the last year. So this is another big one. So let's talk about SB 762.
Well, I do want to take a minute just to give a little bit of background on the state of arbitration agreements in California. So 2+ years ago, California law said that employees cannot sign arbitration agreements. You can't have arbitration agreements in employment context. That went up to the Supreme Court. Supreme Court said no, that violates federal law. California, you have to enable employers to have arbitration agreements with their employees. California came back and said, fine, well, we're going to pass this law, California Labor Code Section 432.6, which prohibits mandatory arbitration agreements and has several other restrictions. That was the end of 2019. The California Chamber of Commerce sued, and that law was struck down temporarily pending a full litigation and full hearing and full decision by the court. We finally got that decision just this last year, a few months ago. We'll talk about that in a moment. But the takeaway here is that I want to start off with: arbitration agreements are still possible in California. We highly recommend them. Sign them with all your employees. Have as many employees sign them as you can. If you're going to have an arbitration agreement, even though I recommend doing it, the arbitration agreement has to meet many different requirements. And with this new law, 762, when you go to enforce your arbitration agreement, you have to pay the arbitrator within 30 days of the due date, or else you lose the right to arbitrate. Meaning if you initiate the arbitration process and you don't pay your arbitrator, then you lose arbitration and you go back to court. One of the requirements in the arbitration agreement is that the employer must pay for all of the arbitration fees. And so this is just another remedy for employees that if the employer doesn't pay within 30 days of the due date, you go back to court.
So this is really on the shoulders of the employer.
Absolutely.
All right.
And here's that case, Chamber of Commerce versus Bonto. Remember, I said that California passed a law that prohibited mandatory arbitration agreements. Well, the court finally decided that mandatory arbitration agreements can be prohibited, but all of the penalties, all of the fines, all of the criminal penalties that were associated with mandatory arbitration agreements cannot be enforced. They're preempted by federal law. And from a practical standpoint, it makes sense that an arbitration agreement must be voluntary, because that's core contract law. Any contract, any agreement must be entered into voluntarily. Any force or any contract made under duress is not going to be enforced. So what we are doing now is we have to work with employers so that they understand that when they go to sign in an arbitration agreement with an employee that the employee can refuse. That the arbitration agreement cannot be mandatory.
Okay, so is there any like bottom line takeaway on this for clients?
Just make them voluntary. Make the arbitration agreement voluntary. Don't have it be a condition of employment. Because if signing an arbitration agreement is a condition of employment, a court will strike down the arbitration agreement and compel you to litigate.
Got it. Okay, here's another one. Herrera versus Doctors Med.
Okay, we've got a bunch of cases this year on arbitration. The takeaway here from this case is that arbitration agreements must exclude Paga claims. We've talked about Paga before. It comes up a lot. It's been a very hot topic lately. Employers want to include Paga in arbitration, but courts are saying no. Because Paga is essentially a police action of the state, and the state is not a party to the arbitration agreement, that the state cannot be, you cannot enforce the arbitration agreement against the state, so you can't enforce it against employees. So the takeaway here is that arbitration agreements must exclude Paga claims.
Which is a bummer.
Yeah.
Okay, all right, Bannister.
Some more restrictions for arbitration agreements. So in this case, the employer tried to restrict and limit some of the employee's rights, such as shortening the statute of limitations, limiting the types of recovery that could be made, and the court said, no, it can't do that. That's not fair. It's overly burdensome to the employee to have those kinds of restrictions. So the arbitration agreement must be drafted correctly and not have any kind of restrictions or limitations on the rights of the employee.
I think you're talking about the next case. This one had to do with the electronic signing of arbitration agreements.
You are correct. I got that mixed up. I'm so sorry.
That's okay.
Yeah, so can we skip forward and skip back?
Yeah, we can.
Okay, so this case says you cannot limit the employee's rights. You cannot limit recovery or statute of limitations, anything like that. The bargaining position must be the same. Okay, can we skip back?
Mm-hmm.
That's what there's a lot of cases here. Don't use e-sign for arbitration agreements. Courts will do any and everything they can to try and get an employee out of their arbitration agreement. So if there's an e-sign on a contract, the employer has the burden of proving or the burden of authenticating the arbitration agreement and authenticating that it was the employee who actually signed. And there's a process that the employer has to follow in order to prove that it was the employee who did the e-signing, such as having a login, or having other credentials, or having other kind of metadata proving that it was the employee. So that's a lot of work, and I don't think it's necessary to go through all that work. So my recommendation is just don't e-sign arbitration agreements. Do a wet signature.
Preferred, but again, we're dealing with a lot of remote workers. We're dealing with a lot of now HRIS platforms where you can upload documents and have employees sign them, right? And so this is really common practice. So this is, I'm not happy about this case. I understand it. And I've seen other cases where some sort of document has been invalidated because there were multiple logins, people could do whatever. But for the most part, Curtis, like the HRIS or payroll platforms where we're using to upload documents for people to sign, they have an individual password protected login. Like they set their own password. We don't even have the right to set the password, right? Like we can change it for them, but once the first thing that they're going to be asked to do when they log in is to change their password again. So if we had a situation like that where an employee is going to log in to something that's password protected and sign an agreement, how would you feel about that?
I would be more comfortable with that because you can demonstrate, you can authenticate that signature. If you have the login, if you have the credentials, you have the metadata, you have the IP address, if you can prove that it was actually the employee who got on the system and e-signed, then you should be okay.
Okay, good. Because the other thing I do see that I don't like personally, but what's your opinion on this, is where arbitration agreements are like tacked on to a handbook, and then the employee is asked to sign as part of the handbook.
Yeah, those will be struck down. Those will not be enforced. The arbitration agreement must be a separate, standalone agreement. It cannot be attached to an employee agreement. It cannot be attached to a handbook. It must be a separate, standalone, separately negotiated and executed contract.
Okay, great. So just again, action item just to pull that out and make it separate. If you can get wet signatures on this, Curtis, it's fine for them once they have the wet signature then to scan and upload and make an electronic document, right, of the arbitration agreement. That's okay, right, that they keep it electronically. They don't have to necessarily keep the original.
Yeah, that is okay. So the biggest takeaway that I have here is, do you have enter into arbitration agreements with your employees, but consult with us first.
Right, definitely. Okay, we're going to wrap up with some industry-specific slides. There's just 3 or 4 of these slides. So if you have any questions and you haven't already dropped them into the question section, please do so now. And then Denise, I know, is watching over these. So this next one, AB 701, is sort of the Amazon rule, right, Curtis, the warehouse quotas. So this is going to apply to if you have a single warehouse with 100 or more employees, or if you have 1,000 or more employees working in warehouses across the state. And basically what they want to do is make sure that you're not putting such strict quotas in place that prevents employees from using bathrooms, facilities, or being able to take their meal or breaks, or that they have to work so fast they're ignoring health and safety laws. So there's details in this. Again, if you fall into this category, make sure you read AB 701 for the details, but it does require you to disclose the quotas to employees beginning January 31st. And it also says, hey, if you take action against somebody within 90 days, right, of them asking about their quotas or their own work speed or complaining about quotas, whether that's inside or outside the company, there's a rebuttable presumption that that was unlawful retaliation. So you want to make sure that if you play in this space that you prepare the necessary disclosures and you take a look at those quotas to make sure that they're not, unduly burdensome. Anything you want to add on that, Curtis?
No, you hit the points. This is primarily targeted at Amazon, the fulfillment centers. I think I have one client in this industry that's going to be affected by this law.
So, okay, we'll jump ahead then. So SB 646 has to do with Paga and Janitorial Workers. So current law allows people to bring Paga claims, and it basically, this exempts employees who are janitors that are working under a collective bargaining agreement. So this bill will expire July 1st, 2028, or whenever the collective bargaining agreement expires, whichever is earlier. And then the next one is garment manufacturers. And we do have a couple of garment manufacturer clients. And so you need to know that you are liable for guaranteeing payment of wages to the employees of any subcontractor contractor you work with. So this, has been similar in the construction industry for a while. It makes you liable if down the food chain, so to speak, you're sending out something to be done that is involved in your final process. You may be liable for those contractors if they're not paying their wages appropriately. The other thing this one does is it's now unlawful to pay piece rate compensation for garment manufacturing unless that's part of a collective bargaining agreement. So that's a pretty big change, Curtis, because that industry has long used piece rate compensation.
It has. I can't think of any clients that I work with that are going to be directly affected by this law. I have clients in the distribution industry of garments, but I can't think of anybody. This is a very niche. This is a very industry-specific law.
Yeah, very specific. So just make sure if you are a garment manufacturer, you're going to pay workers at least minimum wage, and then you could do a bonus on top of that. Contractor pay records, Curtis, you want to talk about this one?
Yeah, I don't think I have much to say here other than we still see instances of subcontractors not paying their employees because the general didn't pay the sub, because the owner didn't pay the general. It still happens, unfortunately. So the law is moving and is trying to eliminate these types of situations where employees are not getting paid.
Right, so that's SB 727, and then AB 1023 has to do with furnishing records to the labor commissioner. And so they just made a slight change on this one. So again, if you're a public work contractor, look at the details on this because there's penalties if you don't furnish the pay records, as required. And that is it for our slides. So we did pretty good, Curtis. Came in an hour and 16 minutes or so. And I am
I'll take
going
it.
to turn it back over to Denise so she can tell us what kind of questions people want answered.
Great, thanks. I was trying to go through the questions and try to at least put them by categories because they come in. So I'm going to start with everyone's favorite category of COVID. So we have a couple of questions that came on that. And again, if you have questions that you haven't put in the box, put them in the box. If we don't get to you today, we will try to circle back with you later. And just to reiterate, for people who had got on the webinar a little bit late, a copy of the webinar will be emailed to you tomorrow. So if there's something that you weren't sure you heard correctly or you want to listen to it again, it'll be emailed to you tomorrow. So check it out. Okay, so on our favorite subject of COVID, is it okay to track vaccination status via a spreadsheet in lieu of having each staff member complete an attestation form?
Yeah, there's actually 3 ways that you can do it. You could actually take a copy of everybody's vaccination card and put it in a file. And reminder that it's confidential information, so put it in either their medical file or keep a separate confidential file for all attest or all vaccination cards. You can have everybody complete an attestation record that just says either they are or not vaccinated. Or the third way is you could actually go around and do some sort of, I could walk up to you, Denise, are you vaccinated? Let me see your card, and then put a check mark in on a spreadsheet next to your name. You can do that as well. So any of those options are good.
So another question came in and said, should we keep a record now of the booster vaccinations because a lot of people are out going to get their boosters?
No requirement to do that. Curtis, any thoughts on that?
I haven't seen any requirements on that.
Yeah, I wouldn't bother.
I don't think there's any requirement to do that yet.
Yeah, I would add this. We had this come up with a client last week. When we first sent out the attestation forms like 4 or 5 months ago, there were 3 people, I think, out of this one small group that said that they weren't vaccinated. They've since moved into a new location and they're back in the office. So I suggested that they go back to those 3 people to see if that status had changed, because otherwise they have to enforce the mask guidelines for those people.
Okay. Let me do one more on COVID and then we'll move on. If an employee is new and not yet eligible for sick pay benefits, but has a physical reaction to the COVID vaccine, is the employer required to pay sick time?
Curtis, that sunsetted, didn't it?
That's what
It did, yeah, in September. That
Yeah, end of
obligation
September.
went away.
I can't think of any specific, unless there's something industry specific. And I don't know off the top of my head, Curtis, we'd have to look at that. But is there any industry like healthcare, anybody that would have that requirement? I can't think of
Not that
anybody.
not that I'm
Yeah.
aware of.
Okay. A couple questions on wage and
Oh,
hour.
hold on one
Sorry.
second. You know what, Curtis? Los Angeles, I don't know if it's city or county, how they do the unincorporated or whatever. That didn't sunset at the same time. So if you're in Los Angeles, there may be a requirement. But whoever asked the question, if you're in Los Angeles, you can look that up. Otherwise, I don't think there is.
Okay. Are you allowed to pay bonuses in a separate check to wage and hour?
You can pay it on a separate check. You could pay it however you want to. It still has to go through payroll, though. It still has to be taxed.
Mm-hmm.
So I don't know what the intent of the question was.
Yeah.
I mean,
We had a question about.
Yeah.
Sorry.
We actually had a client that was paying the base wages through payroll and then issuing them a bonus under a 1099, which is absolutely what you should not do.
Yeah, can't do that.
Yeah.
Okay. So you talked a little bit about keeping records for wage and hour for employees, and it says, can a project management system showing chargeable hours count as time records for wage and hour?
Possibly.
Yeah, the
Depends
question
on
is,
the circumstances, but it might work because the employers are required to have backup data. So it's possible. I would still rather have the clock in and clock out data, but if that's not available or for some reason it's lost or destroyed, that type of evidence can or is admissible to demonstrate what the hours the employee worked were.
and we're looking at a system like that for my own business right now, Denise. And so I would say this is one of the must-haves when you evaluate the systems is that people can show when they went to lunch, right? So the rule is for non-exempt employees, and we're just talking about non-exempt. You don't have to worry about your exempt people. Non-exempt has to show when they started working, when they went to lunch, when they came back from lunch, and when they left at the end of the day. So it's 4 punches if they're going to be taking a meal period and working more than 6 hours. So for example, a couple of the systems we're looking at, they would start the clock basically similar to what an attorney would do, start the clock, say I'm working on this project for this client. So it's charging their time to a client, but it's also going to give us a record of when they started working, right? And presumably there's a gap in the middle of the day when they weren't working, which would be their lunch, and then they would stop working at the end of the day. So I think that would probably suffice. So it would, again, depend on the documentation they'd be able to produce.
There would still need to be a way to demonstrate working time that's non-productive. So whether it's a rest break or training or other meetings, informational meetings, there would still need to be a time to report and charge non-productive time.
So
that's
if they,
still compensable.
okay, so you would want them to be able to basically clock into a break and out of a break and clock into a meal period and out of a meal period?
Yes, a system or an Excel spreadsheet of charging time to the different projects is helpful, but that's not 100% snapshot of the working time of an employee.
Okay, so the person asked the question if they're using some sort of project management software, but they could add meals and breaks as a client almost, right? Or some sort of project time. And then they just have to know to pay the breaks, but not the meal period. And you would be okay with that?
Yeah, so in my own time system as an attorney, I have an account where I can charge office time too.
Mm-hmm. Okay. All right, that would work. Denise?
Okay. Here was a question about AB 1003, wage theft. Does it also include mileage? We have an employee who did not submit his mileage until last week and is now asking for back pay of unreported mileage. I didn't know is mileage included in wage and hour?
It's not.
So mileage is a reimbursement of expenses.
Yeah. So that falls under a different section of the labor code. So it's not wages, but you still have, Curtis, correct me if I'm wrong, but they still have to pay it even if, you can have a rule that says you have to turn it in the month you incurred it or we're not going to pay it, but they can't get away with that. They can have that policy, but they're going to lose, right? But the good news is it's not wage theft, not the same penalty.
It's still strict liability. It must be paid, but it's not considered a wage.
You're not going to prison. How's that?
Yeah.
Right.
Yeah. Okay, quick question on Form I-9. You mentioned Form I-9 earlier today.
Oh, yeah.
Everybody's favorite. What is the reason the I-9 form should be shredded?
because the penalties are so out of control, and I can absolutely with 100%, unless you're using E-Verify or something, guarantee that they are not correct. We audit these all the time, and I have never once gone into a company where we didn't find mistakes. So I will tell you right now, if you have not audited your I-9 forms, call us. We'll set up a time to come in and do it for you, because the penalties are huge. And it's a money grab for sure, but every single little thing, you don't put NA in the right spot, you leave something blank, that's $100. They put the wrong date format, $100. Like, they go through, and every single little ticky tack, form over substance mistake that you make can be just added up. And again, each form, it could be as bad as like $2,100 or something like that per form. So I say just shred them right away. There's no reason to hang on to them. Again, the rule is 1 year beyond employment and a minimum of 3 years, whichever's longer. So if you've worked, I hire somebody, they've worked for me for 10 years and they leave, I need to keep it 1 more year. I hire somebody and they work for me for a day and leave, 3 years. Okay, so minimum of 3 years or 1 year beyond employment. So that's why I say don't keep those around, because you would have to produce them if you got audited and you're going to get fined. So obviously I feel pretty strongly about that one.
Yeah. And just one clarification, Curtis, you talked about severance agreements earlier in the conversation, and the changes. Did you say that the severance agreement has to be open for 5 business days now? I just want to have that clarified.
Yeah, so if I present an employment agreement to somebody on, say, Friday, or sorry, a severance agreement to somebody on, say, Friday, then I have to leave it open for 5 business days. So that's going to be Monday, Tuesday, Wednesday, Thursday, Friday of the next week before I could withdraw that severance agreement.
And it says 5 business days, Curtis?
5 business days.
Okay.
Federal law that requires 21 days for older workers
Yes.
is 21 calendar days. But the state law for all severance agreements is 5 business days.
Got it.
Do I dare ask the age of the older worker?
Oh, it's 40 or more. The feds think you're old
Okay.
at 40, Denise. We passed that one a while back. So
I just wanted to clarify.
Curtis cut out a little bit, but just to clarify. So we've had the Older Worker Benefit Protection Act around for a while. So that one says that, hey, if you lay somebody off or you're going to offer them a severance and you fire them or whatever, you're going to offer them a severance, then it's going to require you to give them 21 days to consider the agreement. And then there's a 7-day revocation period where they can withdraw it after. We always say don't pay it until the 8th day. Right? But they don't have to take the 21 days, but you have to offer the 21 days. So now before we didn't have anything for someone under 40. So now we have this rule, which is 5 business days. So you have to give them that time. You have to tell them they have the right to confer with an attorney. And there's no revocation period for the 5. So you could pay it, as soon as they sign it.
Okay. And then we just had a question, and this probably will have to be our last one. I'm looking at the time. Clarification on the e-signatures. Curtis, you were talking about a wet signature versus an e-signature. And so is the difference that an e-signature sent through the email is bad, but something done on a platform is okay? Because you were mentioning that you had to try to produce a wet signature whenever possible.
Yeah, so if somebody gets a link through an email and they sign that link, they click the link, it pops up the employment, the arbitration agreement, and the system automatically sends that signed copy to the employer. There's an agreement that the signature cannot be authentic.
Curtis, we're losing you a little bit. You're cutting in and out a little bit. I think you're in your car now. Let me try to answer this. So the bottom line is you're going to have to be able to prove that no one else could assign that except for that employee, right? So unless there is a password protected way, for you to say, look, like in my case, we send it out through our payroll system, someone has to log in, they have to sign it there and it resides there. It's going to be hard for the employee to say somebody else signed that instead of them, right? But if it's just like links sent through the email or some other way where it's not password protected, everyone goes into a Google Doc. I've seen that before, stuff like that. That's not going to fly.
Okay. Great. I think that's all the time we have. And I know, Linda, you posted your information and Curtis's information on the screen. So if there was questions that weren't covered or specific questions, especially, they should reach out to you guys.
Absolutely. And if anybody has any suggestions on future webinar topics, please shoot them over to me because we're always looking for good topics. I appreciate everybody attending. We had, I think, 160 people or something today. So definitely a lot of interest in new laws. Again, if you are an HR professional and need HRCI credits, please just put HRCI into the question box, and then we'll shoot you over the link so you can answer the survey and get your certificate. With that, thank you so much, Curtis, for your expertise as always. Thank you, Denise, for moderating with your expertise, and we'll see everybody sometime next month. Happy holidays to everybody. Have a great rest of the year.
Bye.